I appealed the case to the Court of Appeals, New York State Court of Appeals. I was denied to have my case heard. I was told that only 10% of cases do they actually look at. For years I had many politicians address the fire department and the New York City Corp Council to reopen my fraud case, because for many months I had been in the Brooklyn Supreme Court. They allowed me to go to look at the law books when I started doing research and see what I could do about my case that was reversed. I found the fire department law in the New York City Charter that's called 13377, fraud or mistake. This law deals with the fire department pension system, and under this law, if a mistake made, the Board of Trustees has to correct an error. It don't have a choice. It has to correct an error when found that there is an error or a mistake or a fraud made. As far as I know, no other firefighter has ever used this law to help win this pension. This is the law that they go after city workers that committed fraud. But I was asking the fire department and my attorney that I hired, asking them to reopen my case, because this is a two-way street. This law pertains also to people that were denied their pension due to fraud. I hired an attorney, his name was Marlene Gold, in 1996, who handled my case, and we requested that the fire department and the New York City Corporation Council, who was Madga Deconinck again, to reopen my disability case and answer to my causation. We also had help from my union, and many politicians also requested to have this case reopened under this law. They wrote to the politicians, also wrote to the fire department and to the city of New York regarding same. Over a 10-month period, Mr. Marlene Gold had written approximately 12 letters to these parties. For the first time, my union was able to get me before the fire department Board of Trustees to receive an answer to this fraud or mistake law 13377. And they were to call for a vote on my line of duty pension. Problem now was Mary L. Sullivan was still working for the fire department, but even worse, she was hired, she became legal counsel for the fire department. Those memos that she had written were never investigated to this day. They were given to all the Board of Trustees members that sit on the Board of Trustees. The mayor's office back then, the city controller's office, the city finance department, and the fire commissioner, which I believe was Howard Safer back then. No one ever investigated how many years Mary was writing her medical certificates. Even the Brooklyn DA's office, I'll prove, never even investigated. I'll prove that with a signed affidavit. Well, Madga Deconinck was still sitting on the Board of Trustees when my attorney and my union were waiting for a vote to call to try to get me my line of duty disability pension. Now this is 1997 that finally at this board hearing, and this is 3 years after my appellate division reversed my case. The fire department refused to call for a vote along with Madga Deconinck again because Mary O'Sullivan was their legal counsel. The fire department issued a reply, an answer, on 5/19/97 by then Fire Commissioner David Clinton, Chairman of the Fire Department Board of Trustees. The letter states that the law does apply, but not to Michael Romanelli. This May 19th, 1997 letter, which was actually written by Madga Deconinck, it's faxed up here from her, because she stated in a minute she was writing a letter, but it was actually signed by David Clinton, the Fire Department Commissioner of the Board of Trustees. In part it states, from May of 1990 until January of 1992, Mr. Romanelli was afforded not one, but 5 opportunities to submit his evidence to the medical board of the pension fund, the 1B medical board in quotes. Each time the 1B board thoroughly reviewed the newly submitted evidence as well as the entire case in light of that new evidence. Can we believe this? During this process, Mr. Romanelli was represented by counsel, and his attorney presented Mr. Romanelli's case to the 1B board via numerous memorandums. The 52 memorandums were taken out of the court records. They were destroyed by Mary O'Sullivan and Marlene Gold. If during this approximately 2-year process, some medical documents were allegedly not reviewed by the 1B Medical Board, it was Mr. Romanelli's burden to submit them or resubmit them during this period. First they say that the 1B Board thoroughly reviewed all my newly submitted evidence, and now they say, well, if during this time some documents weren't allegedly reviewed by the 1B Board, it was Mr. Romanelli's burden to submit them or resubmit them during this period. How many times have I proven and shown that not only did I submit them, resubmit them, the union submit them, resubmit them, and I had to hire an attorney to submit them and resubmit them, and they still disappeared. This is the kind of politics I'm up against. In the context of the court procedures, it is telling that Mr. Romanelli did not allege that the 1B Medical Board failed to review medical documents. I mean, this is incredible. I mean, in the context of the court procedures, it is telling that Mr. Romanelli did not allege that the 1B Board failed to review certain medical documents. My attorney, Rosemary Cowell, put a lawsuit in 1992 before I retired, claiming exactly the same thing that I stated before. My union stated it on record. My attorney argued it in the memos. And I gave a deposition to the Corporation Counsel in the civil lawsuit when they had me home confined as to what they were doing with my documents from the 1992. However, 13377, it goes on to state, permits the Board of Trustees to adjust the retirement allowance of a beneficiary if a beneficiary receives more or less than what he or she is entitled to as a result of an error or change in the record. This is the first time in history that the Fire Department or the Corporation Counsel has ever admitted that this could pertain to a person that didn't get their pension. I spoke to many disability attorneys and they couldn't believe that I got a response back mentioning this. However, 13377 remains unavailable to Mr. Romanelli, since it was his burden to submit or resubmit these documents to the 1B Medical Board during the application process.